Good evening to all of you. I hope all of you are doing great. So let's start today's discussion. So today we are planning to discuss basically about MP Civil Judge Junior Division 2018 question paper, in which we are planning to discuss specifically shift 2 question paper. If you people remember, then we have discussed 2019 phase 2 and then 2019 phase 1 shift 1 and shift 2 question paper, 2018 shift 1 question paper, and today we are going to discuss 2018 shift 2 question paper, in which we are going to discuss C.P.C, then we are going to discuss Indian Contract Act, then we are going to discuss Transfer of Property Act. Okay, so let's start today's discussion. Now, if you people haven't subscribed to our channel till now, please go and subscribe to the channel and don't forget to press the bell icon, so that whenever me or any of the faculties are coming live, you will get the notification of the same. Apart from this thing, जो भी MP Civil Judge Prelims का crash course है, उसके लिए Rostrum Legal has started a particular crash course in which we are providing video lectures for all the subjects, 10 plus mocks, one-on-one mentoring and doubt clearing sessions. So don't forget to check out the link. Now, today's first question is question number 11, which is stating remedies available against ex parte decree includes, which means which of the following is a remedy against an order passed by the court, which is the ex parte decree. Now, if you people remember that under order 9 rule 13, the court can pass ex parte decree. So which of the following things will be included as a remedy against ex parte decree? Option A, appeal. Option B, review. Option C, application for setting aside the decree, and option D, all of these. Appeal, review, application for setting aside the decree, and all of these. So what should be the correct answer? Yes, question number 11. Anyone having any idea what should be the correct answer? Appeal, review, application for setting aside the decree, and all of these. So what should be the correct answer? Its correct answer will be appeal, right? So this is the remedy available against ex parte decree. Now, next question is question number 12. A caveat shall not remain in force after the expiry of. A caveat shall not remain in force after the expiry of. No, Ankita Gupta ji, 11th ka D is the correct answer, right? I'm really sorry. 11th ka D is the correct answer. That means all of these, right? Not A. So its correct answer will be D, that is all of these. Now, next question, question number 12, a right to lodge a caveat, right to lodge a caveat. Okay, a caveat shall not remain in force after the expiry of 30 days, 60 days, 90 days, and 120 days. What should be the correct answer? A caveat shall not remain in force after the expiry of 30 days, 60 days, 90 days, 120 days. So its correct answer is 60 days. So, 90 days. A caveat shall not remain in force after the expiry of 90 days, right? So C will be the correct answer. This particular question is from section 148A of your CPC. Next question. Question number 13. A receiver is an. A receiver is an. Option A, officer of the court. Option B. No, Ankita Gupta ji, its answer will not be A. Now, if you people will follow up section 148 closely, in section 148, the time period is 30 days. That is the maximum time period for which the court may enlarge the time. But under section 148A, again repeating, under section 148A, that is talking about specifically caveat. So in that, the time period is of 90 days. Question number 13. A receiver is an. Option A, officer of the court. Option B, agent of the plaintiff. Option C, agent of the defendant. And option D, either agent of the plaintiff or agent of defendant. It's depend on circumstances. So a receiver is an officer of the court, agent of the plaintiff, agent of the defendant, either agent of the plaintiff or agent of the defendant. It depends upon circumstances. So what should be the correct answer for question number 13? Yes. Question number 13. What should be the correct answer? Its correct answer will be A for Ahmedabad. That is the officer of the court, right? Now, let's move towards next question. That is question number 14. Right to appeal is option A, fundamental right, option B, constitutional right, option C, vested right, and option D, all of these. So right to appeal is which kind of right? It is a fundamental right, constitutional right, vested right, or all of these. Yes. Ankita Gupta ji, for which question you have marked D? I really don't know. So please specify the question number as well. Right to appeal is option A, fundamental right, option B, constitutional right, option C, vested right, and option D, all of these or all of the above. Question number 14. So right to appeal is a vested right, right? Or you can say it is a statutory right. So it is a vested or statutory right. Clear? Right to appeal is a vested right. Next question, question number 15. Now read question number 15 very much carefully before answering, because this particular question is bit technical, right? The question is, under Code of Civil Procedure, defendant can ask for temporary injunction against the plaintiff if the court can ask for temporary injunction. No, Ankita Gupta ji, its correct answer will be C, that is vested right. 14 ka C is the correct answer. Question number 15. Okay, the defendant can ask for temporary injunction against the plaintiff if option A, there appears to be a danger that plaintiff would waste or alienate the suit property. Option B, the plaintiff threatens to dispose of the property with a view to defrauding his creditor. Option C, plaintiff threatens the defendant to dispose him from the suit property. And option D, all of the above or all of these. Option A, there appears to be a danger that plaintiff would waste or alienate the suit property. Option B, the plaintiff threatens to dispose of the property with a view to defrauding his creditor. Option C, plaintiff threatens the defendant to dispose him from the suit property. And D, all of these. Yes, this particular question's answer is A for Ahmedabad. Question number 15. Its correct answer is your A for Ahmedabad, right? So firstly, I'll suggest you all to read this particular question very much carefully, right? And then answer the question. Now, if you people will read specifically Order 39 Rule 1A of CPC, Order 39 Rule 1A of CPC, you will get the answer of this question, right? Next question, question number 16. Under CPC, when application for review is dismissed, when application for review is dismissed, option A, appeal can be filed against that order. Option B, no appeal lies. Option C, with the permission of court, appeal can be filed against the order. And D, all of these. So, under CPC, when the application for review is dismissed, which of the following remedy is available? Right. Sir, please explain question number 15, Ankita Gupta ji. Okay. Now, let me tell you, if you will read your CPC, that is Code of Civil Procedure, right? And if you will look into when defendant may ask for temporary injunction, firstly, understand what they are asking. When defendant may ask for temporary injunction, so it is very much important. They are not asking for plaintiff, when plaintiff may seek injunction, rather than they are asking when defendant may seek injunction against the plaintiff. So the defendant can seek injunction against the plaintiff only in the case where there is a danger that the plaintiff would waste or alienate the suit property, while B and C options are available when particularly the plaintiff can seek for temporary injunction against defendant, not defendant against plaintiff. That's why I have told you that this particular question is bit technical. For better explanation, I'll suggest you to read Order 39 Rule 1A of CPC. And after the last of this particular session, I am going to discuss Order 39 Rule 1A of CPC for better explanation. I hope it's clear, Ankita ji. Now, so question number 16, its answer will be B, that is no appeal lies. When application for review is dismissed, no appeal lies against such an application. So B is the correct answer. B for Bangalore is the correct answer. Question number 17. Amendments in the pleading relates to. Amendments in the pleading relates to. Option A, Order 6, Rule 15. Option B, Order 6, Rule 17. Option C, Order 6, Rule 16. Option D, Order 6, Rule 18. What should be the correct answer? Amendment in the pleadings relates to Order 6, Rule 15, Order 6, Rule 17, Order 6, Rule 16, and Order 6, Rule 18. What should be the correct answer? Question number 17. Yes. So question number 17, B is the correct answer. That is Order 6, Rule 17. So under Order 6, Rule 17, they are talking about amendments in the pleading. Right? Next question. In normal courts, how many adjournments can be granted by the trial court on sufficient cause? In normal courts, how many adjournment can be granted by trial court on sufficient cause? Your options are option A, 5, option B, 2, option C, 3, and option D, no limitation. So adjournment is particularly defined under your Order 17. Order 17 ke andar how many adjournments can be granted? 5, 2, 3, and no limitation. What should be the correct answer? How many adjournment can be granted by the trial court on sufficient cause? So its correct answer will be C for Calcutta, that is 3. So 3 adjournments can be granted by a trial court on sufficient cause, not more than 3, right? Next question. Question number 19. A suit may be instituted by minor. A suit may be instituted by minor. Option A, in his name. Option B, in his name by his next friend. Option C, guardian of minor in his own name. And option D, relative of minor in his own name. So a suit may be instituted by minor. Option A, in his name. Option B, in his name by next friend. Option C, guardian of the minor in his own name. Option D, relative of a minor in his name. So what should be the correct answer? Question number 19. Its correct answer will be your option B for Bangalore. That is, in his name by the name of his next friend. Now, it is very much important to remember over here that whenever a suit has to be defended by a minor. So when a minor is going to defend a suit, that particular suit is going to be defended by the minor on the name of guardian ad litem. This is also a question जो काफी ज्यादा पूछा जाता है. Question number 18, Ankita ji, there is a limitation. So its correct answer will be C. Next, question number 20. Before filing a suit against government under section 80 of C.P.C, it requires a notice to be given to the government of. So question number 20, it is again directly related with your section 80 of C.P.C, which is stating that when you are going to file a suit against the government, a notice has to be served. Okay? A notice has to be served for how many days? It will be option A 30 days, option B 80 days, option C 14 days, option D 60 days. What should be the correct answer? Before filing a suit against the government under section 80 of C.P.C, it requires a notice to be given to the government of option A 30 days, option B 80 days, option C 14 days, and option D 60 days. What should be the correct answer? Yes, Varunji, 20 ka D is the correct answer, that is of 60 days. So 60 days notice has to be given, okay, when a particular suit is going to be filed against the government. Question number 21. If the appellant withdraws the appeal preferred, 20D is the correct answer. Shrey, yes, 20D is the correct answer, Shreji. Now, 21. If the appellant withdraws the appeal preferred against a decree passed ex parte, the application under Order 9, Rule 13 of C.P.C shall be option A, returned, option B, maintainable, option C, referred for the opinion of the appellate court, and option D, rejected. 21. Question number 21 is again related with Order 9, Rule 13, which is talking about your ex parte decree. So in the cases of ex parte decree, what is the remedy available against the party against whom ex parte decree has been passed? Option A, returned, option B, maintainable, option C, referred for the opinion of the appellate court, and option D, rejected. Yes, what should be the correct answer? Question number 21. Question number 21, what should be the correct answer? Its correct answer is B for Bangalore. Very good, Varunji. Its answer is maintainable. Now, next question is question number 22. The court cannot order execution of a decree as per section 51 of C.P.C. in which of the following ways? Question number 22. The court cannot order execution of a decree as per section 51 of C.P.C. in which of the following ways? Option A, by attachment and sale of property. Option B, a decree for restitution of conjugal rights by sending the husband or wife, as the case may be, to civil prison. Option C, by appointing a receiver. Option D, by delivery of any property specifically decreed. So question number 22, what should be the correct answer? Yes, by attachment and sale of the property, by decree for restitution of conjugal rights by sending the husband or wife, as the case may be, to civil prison, by appointing a receiver, and last option is by delivery of any property specifically decreed. What should be the correct answer? 22. Its correct answer will be B for Bangalore. That is, in the cases of restitution of conjugal rights, the party, either the husband or wife, cannot be sent to the civil prison. So 22 ka B is the correct answer. Next question is question number 23. Procedure for suits relating to matters concerning the family is given in. Procedure for suits relating to matters concerning the family is given in. Option A, Order 32A of C.P.C. Option B, Order 29 of C.P.C. Option C, Order 27A of C.P.C. and option D, Order 30 of C.P.C. 32A, 29, 27A and 30 of C.P.C. So which of the following order talks about suits relating to family matters? Question number 23. What should be the correct answer? Yes, Ankita Gupta ji, 22B is the correct answer. Varun ji, 22B is the correct answer. Question number 23. What should be the correct answer? Yes, 23. Its correct answer will be your option A for Ahmedabad. That is, Order 32A of C.P.C. is talking about suits relating to family matters. Question number 24. Question number 24. Again related with Order 32. Order 32 Rule 1 of C.P.C. states about a minor means a person who has not attained his majority within the meaning of. So here let me explain. Question number 24 is simply asking that what is the age of majority? Whatever is the age of majority as per Order 32 Rule 1 of C.P.C. that definition of majority is taken from which act? Option A, Juvenile Justice Act. Option B, Civil Procedure Code. Option C, Indian Majority Act. And option D, Hindu Minority and Guardianship Act. A, but not sure, sir. 23, you are saying Varunji A. Yes, A is the correct answer for 23. Question number 24. Yes, Order 32 Rule 1 of C.P.C. में जो definition है minor का, that definition is taken from which act? So its correct answer will be C for Calcutta. That is Indian Majority Act. The definition is taken from Indian Majority Act. 24 का C is the correct answer. Very good, Varunji. Next question. Question number 25. C.P.C. Pleading means. What is the meaning of the term pleading? If you people have read Order 6, you people should know the answer. Pleading means option A, plaint or rejoinder. Option B, plaint or written statement. Option C, plaint or written statement or rejoinder. Option D, plaint alone. So, 24. Ankita ji is saying 24 ka A. No, Ankita ji, 24 ka C is the correct answer. The definition is not taken from Juvenile Justice Act. It is taken from Indian Majority Act. So, question number 25. Pleading means. Its correct answer will be B for Bangalore. That is plaint or written statement. So, both of these terms, plaint and written statements, are included in the term pleading. Yes, 25 ka B is the correct answer, Varun ji. Very good. Chaliye. Next question is question number 26. Now, from this question onwards, question number 26 onwards, we are moving towards Transfer of Property Act. Which of the following is a ground for determination of lease by forfeiture? Which of the following is a ground of determination of lease by forfeiture? Ankita Gupta ji, 25 ka D will not be the correct answer. Its correct answer will be B for Bangalore. Option A, on the expiry of lease period. Option B, on breach of express condition. Option C, on surrender by lessee. Option D, on vesting of lesser interest in the lessee. So, which of the following is a ground for determination of lease by forfeiture? Option A, expiration on the expiry of lease period, option B. On the breach of express condition, option C. On surrender by lessee, and option D, on vesting of lessor's interest in the lessee. What should be the correct answer? Question number 26. Yes, I'm waiting. This particular question is interesting, so I think I should discuss this question in detail. So firstly, let me get some of the answers. Then only I will be in the position to discuss this question. Yes, question number 26. What should be the correct answer? Chaliye. Its correct answer is your D for Delhi. That is on vesting of lesser interest in the lessee. Now, if you people know the meaning of the term forfeiture, if you people know the meaning of the term forfeiture means a person acquires the right of another person, right? Yes, Ankita Gupta ji, 26 ka D is the correct answer, right? Just a second. 26, question number 26. I just have to confirm it. Question number 26. Yes, its correct answer will be B, not D. I'm really sorry. Its correct answer is B. Right? Varunji, you are correct. Its correct answer will be B. Next question. Question number 27. The doctrine of part performance is dealt in. The doctrine of part performance is dealt in. Option A, section 52, option B, section 53, option C, section 51, and option D, section 53A of Transfer of Property Act. So the doctrine of part performance is dealt in 52, 53, 51, 53A. Which should be the correct answer? Question number 27. What should be the correct answer? The term doctrine of part performance is inculcated in your option D, that is section 53A of Transfer of Property Act. It is talking about doctrine of part performance. Question number 28, doctrine of lis pendens, that is pendency of the suit, embedded in section 52 of Transfer of Property Act. Doctrine of lis pendens embodied in section 52 of Transfer of Property Act means option A, invalidate the transfer of immovable property during pendency of the suit. 27, D is the correct answer. Yes, D is the correct answer. Ankita ji, Varun ji, both of you are correct. Question number 28, doctrine of lis pendens embodied in section 52 of Transfer of Property Act. A, invalidates the transfer of immovable property during pendency of the suit. Option B, it only enacts that the purchaser pendent light suit is bound by the result of the litigation. Option C, it bar the suit of property during the pendency of the suit. Option D, it protects the right of collusive transferee. What should be the correct answer? Question number 28. Question number 28. Well, like if we will talk about the doctrine of lis pendens, that is pendency of the suit, okay, transferring of a property during the pendency of the suit. What will be the effect of lis pendens? So its correct answer is B for Bangalore. That is, it only enacts that the purchaser's pendent light suit is bound by the result of the litigation, right? 28, yes, B is the correct answer, Varunji. Next question, question number 29. If A transfer house worth rupees 2,000 to B and B transfers a field worth rupees 1,200 and additionally pay rupees 800 in cash to A, the transfer is. So they are asking the nature of transfer in question number 29. So they are stating that if A transfers house worth rupees 2,000 to B and B transfer a field worth rupees 1,200 and in additional pay rupees 800 in cash to A, the transfer is option A, exchange, option B, sale, option C, sale and exchange, and option D, none of these or none of the above. Question number 28 ka no, Ankita ji. B is the correct answer, not C. What should be the correct answer? Question number 29. Its correct answer is, it is exchange. It is exchange. So question number 29, A for Ahmedabad is the correct answer. Question number 30, that is again from Transfer of Property Act. In case of gift, if the donee dies before acceptance, if the donee dies before acceptance, then option A, gift is void, option B, gift is valid, option C, gift is voidable, option D, none of these. Gift is void, gift is valid, gift is voidable, none of these. What should be the correct answer? 29, Varunji is saying B. No, Varunji, its correct answer will be A for Ahmedabad, right? Now, question number 30. In case of gift, if the donee dies before acceptance, then the gift is void, valid, voidable, none of these. So its correct answer will be A. That is, gift is void. If the donee dies before the acceptance, then in that case, the gift will be void. Question number 31. Question number 30 ka yes, B, sorry, A is the correct answer, Varunji. Now, question number 31, Transfer of Property Act. Which of the following properties cannot be transferred? This question is from section 6 of Transfer of Property Act, which is stating which of the following properties cannot be transferred. Option A, interest in the mortgaged property. Option B, right to future maintenance. Option C, immovable property. Option D, share in copyright. Which of the following property cannot be transferred? Yes, Ankita Gupta ji, 30 ka A is the correct answer. 31, what should be the correct answer? So its correct answer is B for Bangalore. That is right to future maintenance. Question number 32. Within the meaning of section 51 of Transfer of Property Act, the transferee, option A, is not entitled to the value of improvement. Option B, is entitled to the value of improvement. Option C, has conditional entitlement to value of improvement. And option D, none of these. So what should be the correct answer? Question number 31. Yes, B is the correct answer, Varunji. Now, which of the, as per section 51 of Transfer of Property Act, the transferee is option A, not entitled to the value of improvement. Option B, entitled to the value of improvement. C, has conditional entitlement to the value of improvement. And D, none of these. So its correct answer is B for Bangalore. Question number 33. A contract of insurance, the performance of which depends upon future event, fall under the category of. Now, question number 33 onwards, we have moved on Indian Contract Act. 32 ka yes, Varunji, B is the correct answer. Question number 33. A contract of insurance, the performance of which depends upon a future event, falls in the category of. Option A, contingent contract. Option B, contract of indemnity. Option C, contract of guarantee. And option D, quasi-contract. So its correct answer will be A for Ahmedabad. That is contingent contract, right? Yes, Ankita Gupta ji, 32 ka B is the correct answer. 34. An agreement to remain unmarried is. An agreement to remain unmarried is. Option A, valid. Option B, void. Option C, option B, voidable. Option C, void. Option D, unenforceable. An agreement to remain unmarried is. Option A, valid. Option B, voidable. Option C, void. And option D, unenforceable. 32. Its correct answer is C, that is void. So an agreement to remain unmarried is void in nature. Next question, question number 35. A contract of insurance is a contract of. A contract of insurance is a contract of. Option A, guarantee. Option B, bailment. Option C, agency. Option D, indemnity. 34, Varunji is saying C. 34 ka yes, C is the correct answer, Varunji. Now, question number 35. A contract of insurance is. Yes, Viniji, 34, C is the correct answer. A contract of insurance is a contract of. Option A, guarantee. Option B, bailment. Option C, agency. And option D, indemnity. Ankita Gupta ji, you are also correct. What should be the correct answer of question number 35? A contract of insurance is a contract of. Which type of contract? 35 ka yes, D is the correct answer, Vinny ji. Next question, question number 37. As per Indian Contract Act, a tradesman leaves good at B's house by mistake. B treats the goods as his own. He is bound to pay A for them. Under section 69 of Indian Contract Act, under section 70 of Indian Contract Act, under section 72 of Indian Contract Act, and under section 68 of Indian Contract Act. What should be the correct answer? Yes, Varunji, 35 ka D is the correct answer. Next, this particular question, question number 36. What should be the correct answer? Yes. So, question number 36. Its correct answer is B for Bangalore. That is, under section 70 of Indian Contract Act, if a person leaves the goods and another person uses those goods, he is liable to repay for the consumption. So this particular thing is defined under section 70 of Indian Contract Act. right? Next question, question number 37. In a contract in which time is not the essence of the contract, the failure to perform the contract before specified time. Option A, contract will become void. It is not when, it will, the word here will be will, right? So the contract will become void. Option B, the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. Option C, the contract will become voidable at the option of the promisor. Option D, contract will become voidable at the option of the promisee. So what should be the correct answer? Question number 37. Yes. Question number 37. Its correct answer will be B for Bangalore. That the contract is still valid, but whatever loss has been suffered by the promisee, he is entitled for the payment of or compensation for such loss. Okay? So its correct answer will be B for Bangalore. 37, Vinny ji is saying D. Yes, Vinny ji, 37 ka not D, it's B is the correct answer. Question number 38. In which one of the following consideration is not required? In which one of the following consideration is not required? Option A, contract of bailment. Option B, contract of guarantee. Option C, contract of agency. And option D, contract of insurance. Question number 37. Yes, Varunji, B is the correct answer for question number 37. Question number 38. In which one of the following consideration is not required? Contract of bailment, contract of guarantee, contract of agency, and contract of insurance. What should be the? Sir, please explain question number 37. 38 ka yes, Varunji, C is the correct answer. Ankita Gupta ji, I'll definitely explain this question after the discussion of some more questions, right? Question number 37. Next question, question number 39. A agrees with B to discover treasure by magic. Under Indian Contract Act, the agreement is option A, void, option B, illegal, option C, legal, option D, valid agreement. So A agrees with B to discover treasure by magic. Under Indian Contract Act, the agreement is void, illegal, legal, and valid. What should be the correct answer? Quite easy question. An agreement to do an impossible act. Under section 56 of Indian Contract Act, it is void in nature. So A for Ahmedabad is the correct answer. 39, yes, Vinny ji, A is the correct answer. 38 ka C is the correct answer, Vinny ji. Next question. Under Indian Contract Act, A and B make a contract grounded on the erroneous belief that a particular debt is barred by law of limitation. What will be the effect? Option A, the contract is voidable. Option B, the contract is not voidable. Option C, the contract is void. Option D, the contract is void because both of the parties were under a mistake. So question number 40, what should be the correct answer? Question number 40. The contract is voidable, the contract is not voidable, the contract is void, and then the contract is void because both of the parties were under the mistake. What should be the correct answer? Question number 40. Its correct answer will be your option B, that the contract is not voidable. If you will read the language of the section 20, 21, 22, there you will easily find that when the mistake of law as to a law not enforceable in India, then in that case the contract is not voidable. So 40 ka B is the correct answer. Varunji, Biniji, both of you are correct. Now, so tomorrow again we are going to meet up early in the morning, somewhere at around 9 o'clock in the morning. Okay. Meanwhile, all of you, please stay happy and stay healthy. Question number 40, Ankita ji, B is the correct answer. If you people haven't subscribed to our channel, please go and subscribe to the channel and don't forget to press the bell icon. And don't forget to check out the link which is providing you MP Civil Judge Prelims Crash Course by Rostrum Legal, in which we are providing 10+ mocks, one-on-one mentoring and doubt clearing sessions and much more. That will definitely help you to fetch additional marks in your MP Civil Judge exam. Now coming back to Ankita ji ka question, question number 37, she wants me to explain more. Now, this particular question is simply stating that suppose there's a particular time, but there's a particular contract in which there is no discussion of time, that what should be the ideal time, right? There is no discussion of time. And Ankita Gupta ji, thank you, sir. Okay, Ankita ji, you can wait, and you like this is what I'm discussing only for you, where the time is not an essence. right? So then in that specific case, what will happen? Suppose the party doesn't perform his part of promise within a reasonable time. Then in that case, the contract will not become voidable or void. The contract will remain valid, but due to the loss of that time, whatever problem has been faced by the promisor, okay, so by the promisee, then in that case the promisee is entitled to the compensation from the promisor, right? That is what they are stating in this particular statement. In the contract where time is an essence, automatically the contract will become void if the duty has not performed within that given time period. But on the other hand, where time is not an essence, then in that case the contract will not become void or voidable, but the other party can definitely seek for the compensation for whatever loss that party has suffered. Very helpful, sir. Thank you, Varunji. Thanks to all of you for your love and support. I am waiting, sir. Okay, perfect, Ankita ji. I hope now your doubt is clear. See you people all tomorrow at 9 o'clock in the morning. Today there was some problem. That's why I was unable to conduct today's session in the morning. From tomorrow onwards, definitely we are going to meet up again in the morning. So take care. Bye-bye. Stay healthy and stay happy, all of you. Good night.